right, some new disturbing video now shedding light on a Kentucky County sheriff who is being charged with the shooting death of a judge inside of his court chambers. Sheriff Sean Steins made his first appearance in court last week. That video is just so hard to be able to watch there, where he pled not guilty. Police say Steins shot Judge Kevin Mullins multiple times last week after an argument inside a Kentucky courtroom. They have not offered any details about a possible motive, but if convicted, Steins could serve up to 20 years to life in prison. So I want to bring in Chief Legal Analyst Khalifa Rhodes' conversation right now. I'm just seeing that, it's so disturbing. I got to ask you first, it seems like there was some time there that was happening, and also to point out, as you mentioned off camera, that that's not where the shooting actually happened, but there was some conversation, it looked like. So this was a crime of passion. Yeah, the original pause is not the shooting. You can see he's looking for multiple angles, and when you look at the entire video, it looks like he got about 4 different shots in that situation. But his attorney argued that exact same thing. His attorney wants the entire video released prior to the shooting so they can see exactly what was happening, because his client is obviously telling them that something else was occurring prior to this happening. And you can look at it. This sheriff was already under a federal investigation. They had lunch together, him and the judge, and so there was already this personal connection multiple days before this shooting took place. And so because of that, his attorney saying, look, he shouldn't even be charged with murder. It should be a manslaughter charge. It should be heat of passion. The judge denied it, kept the murder charge there. But I agree with your assessment from looking at that video. The first approach is this looks like it's something personal. It doesn't just look like a random shooting. Yeah, and also to be able to point out, though, because when you look at what's on video, again, you're innocent until you're proven guilty. Make that point. But the video, I mean, we're seeing people on the video. We're seeing what's happening going on. If you did it, why plead not guilty? Well, you plead not guilty because you save yourself for another day. Pleading guilty, the case is over right there. He goes to prison for 20 years to life. You plead not guilty, you get an opportunity for a preliminary hearing. At that preliminary hearing, his attorney will make an argument for a lesser charge. He'll make an argument for some type of pretrial release. He'll make multiple arguments to try to put his defendant, his client, in a situation where he can get some type of lesser charge than what he was already facing, which was life without parole. And so the goal is, okay, we'll not plead guilty, and we'll figure out what avenues we have. One of the things that the sheriff said is when they were arresting him, just treat me fairly. And he says, hey, they're trying to take and kidnap my daughter and my wife. Now, those are the statements that the sheriff made when he was arrested. And so he must have some alternate type of theory or defense, if he's this defense attorney, to try to figure out how he maneuvers him out of there. I will say this, duress in North Carolina is not a defense to murder. So even if you are under duress, you feel like your life is in danger and someone's threatening you to do something and force you, that's not a defense to murder someone else. Right. So if you're saying that someone was threatening to kidnap your daughter or threatening to kidnap your wife, whatever its allegations are, that still wouldn't be a justification to then do that as a defense in this situation. Okay, so that's in North Carolina, and Kentucky could be different. But the question I have for you now is, when you see the video there and you see the access that the sheriff has inside to be able to speak with the judge. I know there's been other crimes that you and I have both been a part of in history, like Brian Nichols, that happened, I believe, in 2005 in Atlanta, when a courtroom judge was shot and killed by an inmate there inside the courtroom. So do you think here in cases like this, you could have different procedures that would come out of the access of a sheriff being able to access a judge because of something like that? I was right there in Fulton County. I started my legal career in Fulton County, so I was in that process, and I recognized that it was a change. They were still on high alert, and I was there a couple years after it happened, but they had significant changes. What I can say in this situation is when you're in smaller counties, you do have access as an attorney, as law enforcement, to those back chambers. In the larger counties, you don't. Mecklenburg County, you just can't randomly walk back there. But if I go to like a Union County or a Lincoln County, you can go to those places and you have clear access to the judge's chambers, to this back hallway area that the public doesn't have access to. So I do think something like this would spark some type of change. But the caveat is that this is a law enforcement officer, someone that's supposed to serve and protect. Yes. He would be the actual person that would be preventing something like this from happening. So even if you had protocol in place, I don't know how you shield that person off from being access to the sheriff's, from the judge's chamber. Judge. All right, Khalifa Rhodes, we appreciate your insight, giving us such good context on this case right here as we continue to follow it.